Any mention?
Your Lordship, I beg to mention items 20 and 21 on behalf of Mr. Andy Shulai. He's in bereavement, Your Lordship.
2021.
Yes, Your Lordship.
21 is there.
They're connected matters, Your Lordship.
You've informed the other side.
I've not... Oh, this one. 20 and 21.
No objection, Your Lordship.
2 weeks, yes. He's appearing for whom? Respondent.
For the state respondents, Your Lordship.
Senior counsel for states and bereavement. This matter of 2 weeks. Yes.
Obliged, Your Lordship.
May I please, Lordship, Your Lordship, I beg to mention item number 18, the main list. I pray for 1 week time, Your Lordship.
Your Lordship, they were supposed to file one affidavit to bring on record.
We'll be filing in course of the day, Your Lordship, finally getting our signature.
What affidavit?
Additional affidavit to bring in record the...
That the family pension is, she's getting enhanced rate,
yes,
the wife.
MS Bipasa submits that the affidavit as a lot, but this court will be filed in the course of the day. Well, this is matter up to 1 week. Yes.
Please, Lordship. Lordship, I beg to mention item number 19. I'm for respondent number 4.
What's happened to Mr. Gautam?
Lordship, he has some personal difficulty, Your Lordship.
He's not appearing in the High Court.
Lordship, this one, Miss C.B. Savian is conducting counsel.
There's been repeated adjournments from your chamber, that's why. 1 week, yes. Adjourn.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
I beg to mention item 24. Lordship, in this matter, we have already filed a rejoinder.
Where's oh, isn't the hearing? Is the hearing list will be heard? Yes. You have no objection.
We have already filed a rejoinder, Lordship.
2 weeks, yes. Okay.
I'll oblige.
Please, Your Lordship, I beg to mention item number 16. The conductor counsel
Hubinson Hospital.
Yes, Your Lordship.
Yes. After 2 weeks,
Your Lordship.
as the counsel petitioner is indisposed. Yes.
Please, Your Lordship.
Who's that?
My Lord, I beg to mention item number 22 and 23, my Lord. My Lord, the counsel for the petitioner has some personal difficulty, my Lord. Kindly adjourn the matter. The matter may come after 2 weeks, my Lord.
Mr. Pathak.
My Lord.
No objection.
Okay. 2 weeks, 23. Yes. Yes.
Obliged, my Lord. Obliged.
Daily list, item number 1.
On the last occasion, the writ petitioner was supposed to come and inform this Honourable Court whether he's still having any appointment, because he's claiming to be the Sardar of a particular village. But as on the date of filing of the writ petition, he was no longer holding any office. So on that point, we say that the writ petition should have been closed, Your Lordship.
Lordship, I'm pretty that this matter may come at the end of the board as a senior counsel.
Yes, who's there? Have you got instructions? Because he's challenging the locus of the writ petitioner. You got instructions or not? You have received instructions.
My senior must have the instructions.
After some time.
Item number 2.
My Lord, this is the transfer application. I am appearing for, my Lord, respondent number 1. My Lord, friend is appearing for respondent number 2. May I pray, my Lord, this matter be posted for hearing, Your Lordships. 2nd week of March.
What was number 3? What's the matter about?
No, my Lord.
The title suit was filed by me, my Lord. Appears to be in the wrong court, in the sense that, my Lord, it should have been addressed to the assistant district judge. It was addressed to the additional deputy commissioner. Matter was taken cognizance of, my Lord, an interim injunction was passed in my favor. Thereafter, my lord, an objection was filed as to the jurisdiction. So we have preferred the transfer, my lord.
Well, there will be other issues. What happened, my lord, the moment we receive notice, we file an application, my lord, objecting the jurisdiction, my lord, on the ground of jurisdiction. Now, that was filed earlier point of time, before they moved the High Court. Now, they participated in the proceedings. Now, my lord, participating in the proceedings, my lord, on the date it was fixed for hearing, my lord, they moved it unnecessarily. So, my lord, the other question will come, my lord, if the issue is involved in two proceedings, the one which is later in time, that cannot proceed, my lord. So, I will try to convince, not today, your lordship, earliest, my lord, second week of March.
So this honourable court has stayed the proceeding.
My lord, that is there. Their own proceeding has been stayed.
On the issue of, my lord,
You're paying for three is whom?
Number 3, my lord.
the diocese.
And the diocese.
Number 3 dash notice India. Number 2,
Archival Data, Your Honor, he's the secretary.
you're appearing for him.
Yes, sir.
And you're appearing for?
Respondent number 1.
The committee.
Committee.
Okay. As General entered appearance today on behalf of performer respondent number 3. So such notice complete stop. Mr. S.N. appearing for the next paragraph. S.N. appearing for the respondent number 1 has submitted that the matter may be listed for hearing.
Well, one thing, if we can pray, lordship may call for the records. That proceeding is there, because that proceeding has been stayed, otherwise nobody will be prejudiced.
No, we'll see.
Lower court record may be called
We'll
for.
see. It's a matter of transfer. It's
All
not a
the
question of
pleadings are there, my lord.
Well, the second week of March.
yes, the second week of March. It's not a question of appreciation of evidence or something. The appreciation is
My lord, the interim order may be continued.
interim order shall continue until the next day.
Much obliged.
Item number 3.
Yes.
I file affidavit, Your Lordship, in this case.
What's your stand?
Not present.
What's your stand? Yes.
The state is that, Your Lordship, what happened is that the moment we get a order of this Honorable High Court, we have communicated to the MPSC. Then the MPSC has directed us to be routed through this administrative department. Then the file was, the file was pending before the personal department for quite a long time. It was only on 3rd October 2023, the personal department has written to us to be directing the petition to take part in the selection process once the MPSC advertised the post, and accordingly, MPSC has already advertised the post. That was there was no.
Notice was issued to respondent number 4, my lord. Nobody is here on the last occasion.
What number 4? MPSC.
MPSC, man.
Why MPSC contempt against them?
My lord, they are the one, my lord. They were also party in the initial proceeding, my lord. They were party to the writ petition also.
Do you see the affidavit?
My lord, I'm yet to go through, my lord, plus notice.
After the Bihar respondents of 1 and 2 have been filed, however, have they been served? Number 4.
My lord, whether notice has been received or not, my lord.
Come on, order, come on. One, two, three only.
1 to 3, I'm representing for 1 and 2.
Where's number 4?
3 is MPSC, Your Lordship.
Not received notice. Not received. So?
We'll wait for some time, my lord.
Yes, sir. So, will indicate that notice service report on respondent 3 not complete. This up to 2 weeks. Yes.
Item number 4.
Same.
Item number 5.
Please, Lordship. Lordship, I have filed my rejoinder.
You're appearing for?
For respondent number 6.
The proceedings are complete. Are the proceedings complete? Yes. We take your word for that. As the party submit proceedings complete, this is matter for hearing in the usual course.
Item number 6.
Please, Lordship, in this matter, Your Lordship, as per the last order dated 31/1/2024, I was asked to find the RPGP service to the respondent number 6, Your Lordship. However, I received a letter from the post office that they have not received even the private respondent number 6 also. And as per the private respondent number 5,
I don't understand. What are you saying?
No, that there was an order to file the RPGP service on private respondent number 6. But we have received the letter from the post office that have not been.
Take fresh steps on 5 and 6. That means.
Yes, Lordship. I will take the fresh step for both private respondent 5 and 6, Lordship.
Mr. P.T. Sangma, please be allowed to take fresh steps on respondent 5 and 6 in as much as the notice on respondent 5 return unserved and the status report are available with regard to respondent number 6. Prayer is allowed less after 2 weeks. Yes.
Lordship.
Steps to take it within 3 days.
Lordship.
Prayer allowed to take it after 2 weeks.
Item number 7. Item number 7.
Please, Your Lordship. Lordship, I'm praying if this matter may be placed at the end of the board. Instructions are with the council appearing in this matter, Lordship.
Yes?
Instructions are with the council appearing in this matter,
Who's
Lordship.
the council appearing for the matter?
B. Kharwan Lang, Lordship.
They're allowed to obtain, to take double pension.
Lordship.
She's supposed to come with some.
You're supposed to know also.
Lordship, actually, in fact, on the last occasion, my colleague says that she'll come in instruction whether the writ petitioner, Irene Lingdor, can draw 2 pensions.
Exactly.
So far, I'm concerned, I'm ready to extend the benefit, Your Lordship.
Even if they're MLA and MTC pension.
If there's nothing wrong, then I can do that.
The MP also, MP, MLA, MDC, all pensions, they can draw.
It's a risk for them, not for me.
Not pay,
I'm ready to
after
pay.
some time.
Obliged, Lordship.
Item number 8.
Where's the petitioner? Where's your senior?
The senior is
Where's he? What's his name?
Subrata.
Jasprit Singh?
Subrata Datta.
Oh, Mr. Datta. Where's the petitioners? Yes.
I apologize, Lordship.
Yes.
Lordship, in this matter, Lordship, as per the last order, we were supposed to file rejoinder. It has been filed, Lordship.
Yes, so we'll take it up today.
Lordship, actually,
Lordship,
the conducting counsel is out of station. So
Tomorrow?
Lordship, anytime on Monday, Lordship, if...
Mr. Datta, they just filed a jointer. We'll post it on Tuesday. We'll dispose it off.
Lordship.
A jointer after has been filed by petition number 2. This is the matter for the orders on Monday, on Tuesdays.
Lordship, along with this item, item number 13 is also connected, Lordship.
Yes, we got the item number 13.
Yes, Lordship.
On today's list, yes.
Highly obliged, Lordship.
Item number 9.
Sorry.
Please, Your Lordship, notice has been served to the private respondent on 29/12/2023. Lordship.
What's the matter about?
It's regarding the transfer matter, Your Lordship. The petitioner.
Transfer?
The petitioner, yes, Your Lordship. The petitioner routine transfer has stopped for the second time by the respondent authorities without giving any justification and reason.
My Lord, we have sought for instruction. We are waiting for the instruction.
What instruction? Since you've sought instruction since 7th.
Not yet received, madam.
MS Rahman, right?
Your Lordship.
Submits that the notice is the 1/6 has been since been served. So as such, service is complete. What about You got status report?
Your Lordship will file the affidavit. Yesterday only we received the
Submits
status.
that 6 been served. She prays that she will have to file an affidavit indicating service. Stop Ms. Ensign Con, Leonard GA, prays that you will have further 2 weeks time to obtain instructions. 2 week or 1 week?
Well, 2 weeks.
Yes, prayers allowed. Prayers allowed, yes.
Item number 10.
May please, Lordship. I'm praying for some more time, my Lord, to ascertain the status of service on
Number 6. What's the matter about?
Regarding appointment, my Lord, in lieu of the land.
Yes, Mr. S. Deb prays you allowed some time to obtain status of service on spot number 6. Just after 1 week or 2 weeks. Yeah.
Much obliged.
11.
Lordship, in this case, I'm yet to receive instruction. I may be given 3 weeks' time to get instruction, Lordship.
6, yes. Mr. Abraham prays for allowed further 2 weeks' time. What about you? You file affidavit? This similar submission made by MSEB Pasa. Releases matter after 2 weeks, yes.
I'll oblige, Your Lordship.
Much please, Lordship.
Item number 12.
Wait, please, Your Lordship. I'll be requiring further 3 weeks' time, Your Lordship, to file affidavit.
Yes?
My Lordship, if an earlier date could be provided, as it is, the matter has been extended for a long time, My Lordship.
Give you 2 weeks, yes. 2 weeks for the time as prayed. Allowed for affidavit instructions, yes.
Much obliged.
Hearing. Supplementary list, item number 1.
Lordship, on the last occasion, Your Lordship, with reference to the judgment of the Supreme Court, 2023, Volume 8, page 50, I have pointed out that
1 second. You'd given yesterday 2 judgments, correct?
Yes, Lord. Volume 8.
2023.
Volume 8.
Volume 8.
SCC 50.
Just come again. 2023. 8 SCC.
Volume 8. SCC 50.
50.
And I refer to para 10. Para 10. At this stage, it is required to be noted that as per the settled position of law, pre-referral jurisdiction of the court under section 11(6) of the Arbitration Act is very narrow and inheres 2 inquiries. The primary inquiry is about the existence and validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant privity to the said agreement. The said matter requires a thorough examination by the referral court. The secondary inquiry that may arise at the reference stage itself is with respect to the non-arbitrability of the dispute. Both are different and distinct. In my case, Your Lordship, I have both these challenge. First thing is this, that there is that the arbitration clause which is there in the contract agreement stands extinguished in respect of those claims which are already referred to the arbitration, and it makes an end. And unless the arbitration clause or contract agreements provides such a second reference, such a second reference cannot be granted. And I have also, and this point, Your Lordship, is required to be answered by the referral court. If it is raised, the court is bound to answer this question. Second question is about the arbitrability of the arbitration, whether the claims are arbitrable or not.
No, non-arbitrability of the dispute.
Yes, non-arbitrability of the disputes. I have my objection with regard to this, that the claims which were referred and decided by a competent arbitral tribunal, once the principle of res judicata shall apply, and the claim cannot be again referred to and decided, because these are already being decided once.
Okay.
And this award, Your Lordship, yesterday I have pointed out, was set aside on merit. The court has, the commercial court has gone into the entire aspect of the matter. My learned friend has made a submission before the commercial court that he wants the award to be set aside. Court said that no, just by one party is telling to set aside the award cannot be set aside. It was not a consent order, and the court has gone into the record and passed the judgment, set aside the award. Then, second non-arbitrable point is that there is no, the arbitration agreement does not provide for second reference.
Okay.
Then third one is, my learned friend cannot have the benefit of section 43(4) so as to exercise the right.
Okay.
And the last one is that there is a waiver.
What do you mean there's a waiver?
A waiver in the sense, Your Lordship, the day award was passed, my learned friend was fully aware that one part of my section 16 application is not decided. As a matter of fact, in my section 16 applications, I have raised limitation from two points of view. First thing, I have stated that the claims are barred by limitation under Article 137 of the Limitation Act. That was my first objection, that claims are barred by limitation under Article 137. This point, Your Lordship, was answered by the arbitral tribunal.
Claims were barred under
137, which prescribe a period of limitation of 3 years.
Yes.
And this point was already decided
By the commercial court.
by the arbitral tribunal. By the arbitral tribunal. And second point, with regard to the limitation, which I raised before the arbitral tribunal was this, that a 15 days time is provided under the arbitration clause, Your Lordship. That if a dispute arises, he has to raise the dispute first before the site engineer.
No, you're not going back in time.
Yes, not going back, not approaching the chief engineer within the stipulated period of 15 days.
But that had gone for arbitration after that.
Yes.
Then is that relevant?
Then, Your Lordship, that point is quite immaterial.
Immaterial, yes.
Immaterial. Only the question of limitation under Article 137, that was already decided. That was already decided by the order.
Sequential limitation under Article 130 is already decided.
Already decided by the tribunal.
Okay.
Only with regard to the 15 days time,
yes,
there was no order of the arbitral tribunal. Because the award on merit was against my learned friend. He took a recourse that let the arbitral award be set aside, and on his own request, he got the arbitral award set aside, Your Lordship. And court also, commercial court also has not set aside the award either on consent or on the submission of the learned friend. Commercial court has gone into the records and thereafter set aside the award, but gave him the benefit of Section 43(4). And his case is this, that since I am given benefit of Section 43(4), therefore I am entitled to have a second reference or de novo. And I have pointed out to Your Lordship yesterday, Section 43(4) does not confer any such right. It's only about the period of limitation. The time which he has spent, that will be excluded. Supposing instead of arbitration, he goes for civil suit. I may point out, Your Lordship, here, civil suit is not barred. But with regard to the second arbitral reference, there is a bar unless the arbitration clause so provides for the second reference. Your Lordship, I will refer to first one judgment of the Calcutta High Court, AIR 1958, Calcutta 490. It is there, Calcutta 490. Your Lordship, paragraph 10. Paragraph 10. It will be convenient to state first, Lordship got it?
At page?
Paragraph 10, Calcutta.
No, what page? Paragraph 10?
Calcutta.
Yes, it will be convenient to state that is page 493. Yes.
Yes.
It will be convenient to state first what?
Yes, Your Lordship. It will be convenient to state first at one place the several findings of Bachchat Justice, each one of which raises an important question of arbitration law, and all but one of which were challenged before us. They may be summarized as follows. In the case of an arbitration, without intervention of the court, after an award has been set aside, there cannot be second reference of the same dispute under the same agreement to the same or another arbitrator except when the agreement itself provides for such a reference or when the first reference was invalid, so that in reality there had been no reference at all. So there are two things here, that if the first reference itself was invalid, then he can go for fresh reference. Or it is provided in the contract or in the arbitration agreement, and here in this case, both the things are not present, Your Lordship. Then I refer to one more para, 10.4.
So you mean to say that this award was totally set aside, and then there's no scope since the arbitration agreement does not contemplate a second reference. And that the award has been set aside on merit. And so there's no question of re-agitating the entire thing.
Yes.
That is your case, sum and substance.
In sum and substance, this is the case, Your Lordship. Okay. This is the case. And paragraph 4, Your Lordship, 10.4.
Yes.
But where there was no invalidity, either in the reference or in the proceeding, and the award is set aside on some ground other than its nullity without suppression of the reference.
Or supersession.
Yes, supersession of the reference, the arbitration agreement may survive as it does, but the original reference can be revived or continued and a fresh award obtained on it only if there is a sufficient machinery for further arbitration in that reference, or where the agreement provides for the appointment of a new arbitrator in the place of the original arbitrator in the event the award made by the latter being set aside, or where it gives further authority to the original arbitrator to make another and a new award. What is meant here, Your Lordship, is there has to be some mechanism for having a second reference. Otherwise, Your Lordship, there will be no end of this litigation. The arbitration will be pointless, because time and again, people will go for the second reference. If they lose or if they find the award is likely to be set aside, on some point they may say, oh, let the award be set aside. And court is happy that without any labor, award is set aside and the case is closed. Then go for second reference. So, Your Lordship, the second reference, though this case, Your Lordship, I may also point out, though this case was under 1940 Act, but the principle of law, Your Lordship, would guide this court also. Then, Your Lordship, one Supreme Court judgment also I point out, 1962 SC 1123.
Yes, AIR also.
AIR. Your Lordship will come to paragraph 9.
Yes.
Paragraph 9, the last portion, I am reading it. We are therefore of opinion. Lordship got it?
Yes.
We are therefore of opinion that whatever may be the position in the absence of a provision similar to Section 19, Your Lordship, that Section 19 is under the old Act. Similar provision does not exist in 1996 Act. Supreme Court says that we are therefore of opinion that whatever may be the position in the absence of a provision similar to Section 19 of the Act, there can be no doubt that Section 19 gives power to the court not to supersede the reference and so leave the arbitration agreement effective even when it set aside the award, and thereupon it will depend upon the terms of the arbitration agreement whether arbitration proceeding can go on with respect to the same dispute or with respect to some other dispute arising under the arbitration agreement. This was the view taken in the Barango's jute factory case, which I have just referred to. Supreme Court referred to this Calcutta judgment and said that even in absence of such a provision, that second arbitration would lie only when there exists in the agreement of such a reference. Your Lordship, I may just point out few dates.
From the facts of this case?
From the facts.
You came back from the law to the facts?
Because, Your Lordship, this case was this, I have to point out what is the parameter of Section 11(6), to what extent the court can go and court may leave the matter further to decide by the...
You got the latest decision. That is Lombardi Engineering versus Uttarakhand Jal, Vigian something. I think it has got a neutral citation. Its date of decision is I think 26 November 2023. You just examine that decision also. I cannot go through it, but I've just looked at it, I had a glance at it by this This Supreme Court only digested a lot of these judgments with regard to 11.6 and the scope of the court in 11.6.
Yes,
Can you have a look at
so
that?
for scope is concerned, there is no dispute about it, that it lies.
No, that judgment does. Mr. Thomas, are you aware of that?
Lordship, please, Lordship.
Are you aware of the judgment? It's just last November.
No, Lordship, series of judgments. I have given submitted.
No. There's another judgment also, 11.6, with the scope of, referral code with regard to section 11.6.
I will go through those. I will make submission. I will read it. That Uttarakhand Bijli, no?
Yes, Lombardy Engineering versus some Uttarakhand Jal, something to do with Jal Udyog or Jal, something like that.
Yes, in fact, Your Lordship, if I recall, that also in the context of the 2023 8 SCC, Justice Chandrachud has given one judgment after this on 11.6.
On? When is this judgment?
This has come, Your Lordship, in 2023 volume 9
you
or
don't
10.
mind, I just get my phone. मेरा phone लियो. मेरा phone. I just give the legal citation. Just have a look at it. It's not reported as yet, I think.
My lords, I am in another matter, but may I assist the trial? My lords.
One second. Oi, my pen's leaking also. Right issue. Tissue ले आओ पूरा ठीक हो रहा है. I didn't notice. So engrossed in taking down, I noticed that my hands all become green. 1 second. This neutral citation is 2023 INSC, the Supreme Court, INSC 976.
976?
Well, 976, yes. INSC. It is 2023 INSC, the neutral citation 976.
Party's name, sir?
The name of the parties?
Yes.
Lombardy Engineering Limited versus Uttarakhand Jal Vidyut Nigam Limited.
Judgment delivered by, I think...
by Justice Partiwala. It's a long judgment, 88 pages. That's why I've not had time to go through it yet, but it's on 11.6. And what I see is that it's been, a lot of judgments have been digested here. So I don't know whether it's regard to second reference or just the scope of 11.6.
No, Lordship, there is no second reference. That's my submission. Only one reference.
There's one reference. No, it was the scope of 11.6. It's November 6, 2023.
We will go through. My learned friend said there is a second reference. Only first reference.
Okay. Thank you. Yes. Yes. Which judgment is that?
Your Lordship,
facts, you said.
I was just pointing out few dates.
Yes.
Your Lordship, the agreement is dated 10/1/96. And first notice for arbitration.
The agreement is 10/1/96.
10/1/96.
Okay.
Notice for first arbitration is given on 12/3/2003.
12/3/2003.
And on 18/1/2020, award is passed.
Okay.
Then on 28/6/22, award is set aside.
Okay. Set aside.
Set aside. Then on 15/7/22, he gives notice that claims may be again referred.
It is for yes.
And we have given him a reply that Government of India has introduced a scheme for conciliation, and if you are interested, you can avail that. And he opted for that, but conciliation did not work out, and matter remained there where it was. Then he issues another notice on 26/6/23 and sent a reminder on 18.
Sorry, reference.
Second reference, and sent a reminder on 16/8/23. Then we give him a reply on 18/8/23. I'll just point out.
Now 16/8 he sends a reminder.
Yes, Lordship. 18/8/23. We give him over reply. I'll just refer to your Lordship, page 93 of the petition.
This is very relevant.
Yes, your Lordship. To show that.
We finish with judgment, no? With this 6-2 judgment is over. You don't need to refer anymore.
11/6 I don't need.
No, 62. I mean the 6-2 judgment. You don't require it.
No, 1962 is required.
No, I mean any further for argument.
No.
Yes. Yes.
Your Lordship will see. Page number 93, 16/8.
Page number
93.
93, okay.
93. It's a letter dated 16/8/23. He talks about all his claim. Then I take your Lordship at paragraph 19.
323 is annexure 17.
I take to your Lordship paragraph 19.
You see, this is a reminder?
Yes, this is a reminder.
Okay.
BEL, that is Bhagiratha Engineering Limited, was therefore constrained to take recourse to clause 60.
Reading para?
I am reading para 19.
Of its annexure?
Yes, Lord.
Yes. BEL was therefore, yes.
Yes. 16/8/23.
Yes.
BEL was therefore constrained to take recourse to clause 26 of the contract and continue with arbitration as invoked under its notice dated 15/7/2022. It is pertinent to mention that before CCI only claim 1, 2, 3 were referred as per the CCI means
the reconciliation process.
This is a conciliation body,
okay,
consisting of independent expert,
okay,
were referred as per the understanding of the party as detailed in the referred letter. Since BEL is invoking the arbitration clause, all the dispute, claim number 1 to 6, excluding claim number 7, 8, as mentioned in Annexure 8 to the letter dated, which were referred in the first arbitration case, are being referred for arbitrations. List of claims dispute to be referred are enclosed herewith as Annexure A. And there is no dispute that the claims which were already referred are again being referred in the second. Now, Your Lordship, we give our reply at page 100.
1 second. Yes.
At 100 we gives the reply. The claim disputes which are sought to be referred to the panel of arbitrator were already referred and were subject matter of adjudication between the parties, and the arbitral tribunal awarded a total sum of rupees 4.59 crores under various heads in your favor, wide award dated 18/1/2020. The disputes claims were decided on merit. The award dated 18/1/20 was assailed under Section 34 of the Arbitration and Conciliation Act 1996 before the Judge Commercial Court Shillong, and the Judge Commercial Court, via its judgment and order dated so-and-so, had set aside the award on merit. Those submissions were made by both the parties to set aside the award. The award was not set aside by a consent order, but was set aside on merit. That this was our stand. We said that it is already decided, and in the last we states that paragraph Roman 6, BEL attempt to initiate arbitral proceeding in respect of the disputes constitute a default in compliance of BEL of the condition of said OM NIPCO, hereby notify BEL of its decision that no arbitration proceeding can be initiated in respect of the claim dispute, since doing so would be in violation of the terms of so-and-so, in terms of the paragraph 4 affidavit of undertaking. This decision is binding on BEL. BEL is therefore called upon to withdraw its letter on 20th/6/23, 28/6/23 and 16/8/2023. NAPCO, however, remains open to resuming the conciliation. So, Your Lordship,
that means you shut the door on them with regard to arbitration.
Yes.
So you shut the door on them that we're not entertaining your
arbitration
plea
for
any
the
further
regions,
arbitration for the reasons that the award has already been set aside on merit.
Yes.
And that so there's no more, they cannot be second reference.
Yes.
But you can come to settle disputes.
On conciliation.
But disputes still remain, that means?
No, conciliation. And conciliation, Your Lordship, failed. Conciliation failed. After the conciliation failed, he issued this second notice that arbitration, by invoking the arbitrations. Then we raised our objection by page 100. Initially, he agreed for conciliation, and he has given one affidavit also. I'll just point out to Your Lordship.
Now, one question that we have to examine the judgment of the commercial court, Mr. Jindal. Because your stand, is basically on that the award was set aside on merit.
Yes.
Now, merit means merit as to examination of the claims, or merit as to procedural legality, or on what merit was set aside? What is the...
That, Your Lordship, is not clear from the award. And the court, commercial court has said that he has gone through the records and found these are the infirmities, and on the basis of this, the award is set aside. And not on asking by my friend or giving consent on my part. Even if it is set aside otherwise, if the reference itself was invalid, then there is something still left out because
so because we see what the mind of the court is that the thing is that what will the main point of adjudication is whether the award, now commercial courts setting that award is on merit, procedural infirmity, or on the consent of parties.
Your Lordship, there
whether
is no
leaves any window for any second reference.
No, Your Lordship, window is...
for you, window is non-existent.
No, window...
For them, the very fact that a commercial court allowed them the benefit of whatever it is, it might be cloaked in a different word, but allowed the benefit of section 43(4). Implication of that direction of commercial court is that, yes, there are issues, the second reference is allowed, and that portion of, that when the award's pronounced and when you come,
that
will be washed out. They can go ahead.
That will be deducted.
Yes.
There is no dispute about that. No dispute about that. But that section, Your Lordship, does not give liberty to the party to go for a second reference.
Yes, I mean, you were sent
and that second reference will...
I mean, if we go through the order of the commercial court.
Yes. Yes, Your Lordship.
To cut down the... Yes. Now, your point is that, fine, there's no in the arbitration agreement, there's no provision for second referral.
Yes.
And then these claims have been adjudicated, award was made of a certain amount of money, that has been set aside with the award being set aside.
Yes, Lord.
And so conciliation only is the only option, which also failed. And so that means the doors are shut, but civil suit, maybe they can pursue civil proceedings if they so deem it fit. But with regard to recourse to arbitration, that's over.
That's over.
That's your case.
That's over. And this is with regard to the existence of the arbitration clause with respect to the disputes which are already settled.
Exactly. No, of course.
Yes.
For your standard, disputes already been thrashed out, over.
Yes. Other area on other point is this. My case is this, that the claims are barred by the principle of res judicata.
Okay, yes. Res judicata, yes.
Res
judicata. That other point.
judicata.
You address that point, yes. How would he bar res judicata?
Res judicata, Your Lordship. Because same claims.
Okay, the next ground is bar res judicata. Okay.
Same claims which were referred and decided by a competent tribunal under a valid reference are sought to be again referred, which is not permissible under the principle of res judicata. And my learned friend has raised the point in his reply, rejoinder reply, that...
Here, it's already been filed.
Rejoinder is there. Rejoinder reply that principle of res judicata are not applicable to the arbitration proceedings. In this connection, Your Lordship, I will refer to judgment.
Yes.
One is 1989, 4 SCC, para 4 SCC 595, para 16.
Okay.
With regard to the submission, Lordship got it?
Yes.
With regard to the submission as to the applicability of the principle of res judicata as provided in section 11 of the Code of Civil Procedure to arbitration case, it is to be noted that section 41 of the Arbitration Act provides that the provision of the Code of Civil Procedure will apply to the arbitration proceedings. the provision of res judicata are based on the principle that there shall be no multiplicity of proceeding and there shall be finality of proceedings. This is applicable to the arbitration proceeding as well. It is convenient to refer to the decision of so-and-so wherein it has been held that the principle of res judicata will apply even to proceeding under Article 32(2)26 of the Constitution of India. It has been observed that now the rule of res judicata, as indicated in Section 11 of the Code of Civil Procedure, has no doubt some technical aspects. For instance, the rule of constructive res judicata may be said to be technical, but the basis on which the said rules rest is founded on the consideration of public policy. This is important, Your Lordship. It is in the interest of the public at large that a finality should attach to the binding decision pronounced by court to competent jurisdiction, and it is also in the public interest that the individual should not be vexed twice or with the same kind of litigation. If these two principles form the foundation of the general rule of res judicata, they cannot be treated as irrelevant or inadmissible even in dealing with fundamental rights in petition filed under Article 32. Now, Your Lordship will find here, this, my learned friend may argue, that this case is under the old Act of 1940. In 1940, there was a specific provision under Section 19, which says that Code of Civil Procedure will be applicable. Here, in the 1996 Act, Your Lordship, the provision is little different, Your Lordship.
Because it says that it is not, because this new act says it should not be bound. It shall not be bound by the CPC or by Evidence Act.
Yes,
correct?
Yes, not
It's
bound.
not bound. Yes.
Not bound.
Then
the principle of res judicata.
Not bound by technicalities, you mean?
Yes.
But principles will apply.
Principle of res judicata, Your Lordship, would apply because these are based upon the public policy. And in this connection, Your Lordship, I may also refer the judgment of the Guwahati High Court in Dore Sangma's case.
Dore Sangma case is fundamental principle of judicial procedure.
Yes.
That's all.
Your Lordship, with regard to res judicata also, paragraph 22.
But the thing is that is clear that CPC is applicable in spirit. And that means that just in spirit means also that you cannot give or go by to the set principles.
Yes,
so that's why a right to be heard, natural justice. So that is like inborn in every judicial proceeding.
Yes, even the principle of res judicata, Your Lordship.
So you say that res judicata inborn like is as good as natural justice.
Natural justice. Yes.
So it's equivalent to that.
It is born. It is inborn. Even if CPC applies or does not apply. And in 1996 Act, Your Lordship, what is provided is that the arbitral tribunal will not be bound.
Yes.
But if they want to apply, nothing stops them. Nothing stops them.
Interesting.
And
not be bound. That means that
if they want to do certain things procedural way, if they want to adopt their own procedure, nothing prevents them.
No, correct. Arbitral tribunal can determine its own procedure. That's correct. But you mean that procedure and policy is different?
Different, Your Lordship.
Or principles?
Yes. So, if Your Lordship permit, I can read the Dore Sangma's para 22.
You can read Dore Sangma. Yes. 89(1).
Yes.
Yes. And that is very famous. I think all the juniors should know the judgment also. I hope they are aware of it.
Citation I may give.
This isn't just GLR, no?
GLR
this is
and GLJ also.
120, yes.
1982, 88 to GLR 120. Para
1988, one second, 1988 to?
Gauty law reports.
1988 to GLR.
Gauty law reports, page 120. Yes.
Page 120, paragraph 22.
Yes.
The contention of the learned Advocate General Meghalaya is that the matter relating to nokmanship of the acting in question having been decided in favor of the petitioner as early as on 4/1/37 by the then Deputy Commissioner in case number so-and-so. Any fresh decision in the matter is barred by principle of res judicata. It has been urged that even if the spirit of the Civil Procedure Code were not to apply to the proceeding under the Act, the principle of res judicata would have application. To substantiate this contention, we have been referred to so-and-so case, in which it was held that the spirit of Section 11 of the Civil Procedure Code was applicable in Nagaland. Same view was taken in so-and-so. This view, however, could be taken because the spirit of the code was applicable inasmuch as the matter was adjudicated upon by the Deputy Commissioner. In the present case, however, even the spirit of the code is not applicable as noted above. Shri Lahiri has urged that would not make any difference in view of what was stated in Satyanathan so-and-so case, wherein it was observed that even if Section 11 of the Civil Procedure Code does not apply, the principle of res judicata has been applied by courts for the purpose of achieving finality in litigations. This view was reiterated in so-and-so, wherein it was held that the rule of res judicata is an essential part of the rule of law, which is the basis of the administration of justice on which the Constitution lays so much emphasis. It was pointed out that it is in the interest of public at large that finality should attach to the binding decision pronounced by court, and it is also in the public interest that the individual should not be vexed twice over the same litigations. In Lalchand so-and-so, it was observed in para 19 that Section 11 of the Code is not exhaustive, and the principle of which motivates that section can be extended to cases which do not fall strictly within the letter of the law. It was pointed out that the principle of res judicata is conceived in the larger public interest, which requires that all litigation must sooner than later come to an end. The principle was said to be founded on equity, justice, and good conscience, which requires that party which has once succeeded on an issue should not be permitted to be harassed by multiplicity of proceedings involving determination of the same issue. Because of what has been stated above, we are of the firm view that principle of res judicata, which is founded on equity, justice, and good conscience, has to apply to the proceeding before the revenue member also. So, even if there is CPC does not apply,
yes,
principle of res judicata will still apply.
To bring finality to any.
Yes,
but this case, whether there is a finality or not. See, one thing,
here
Mr. General, sorry to interrupt. The thing is that we have to look at the the facts of the current case.
Yes,
that is why we'll go to the commercial court judgment to see whether there was any finality, that he said that's final, the award, and setting aside the award was on what basis. That's the only thing this court has examined.
Yes, Lordship.
And if we find that setting aside award was really on merits, then maybe your arguments would be accepted that your second reference is not permissible.
Yes, yes. But here the point is this, Your Lordship. The issue relating to his claim have gone into by the competent arbitral tribunal.
No, has the commercial court noted that also?
The commercial court, Your Lordship, I have pointed out, I may again read the judgment. Your Lordship will
We have not read the judgment of the commercial court at all.
26 Page number 26.
We have not examined here in the arguments the commercial court judgment at all. Maybe
Only I read
one line.
yesterday. I read yesterday, but
One line, 2 lines.
not, of course, two or three paras I read.
Yes. Yes. Let's see the commercial court judgment. Setting aside also what consideration?
29.
That
Page
we'll see.
29.
Yes.
The parties have exchanged the pleading. As such, this application has come up for final hearing.
Yes.
The learned counsel Shri V.K. Jindal, assisted by E. Marvin, present for the petitioner applicant. Learned counsel for the respondent Shri George Thomas, Shri Sarup George, Shri R. Grun and Srimati A. Sangma present. And eventually, the argument is commenced by the applicant. However, in the instant case, the learned counsel for the respondent has initiated the hearing of proceeding by making a fair submission that the impugned award does not pass the test of the statutory requirement under Section 34 of the Act 1996. As such, it is not sustainable. That is his submission, Your Lordship. This court finds that it will be necessary to examine the records and the pleadings of the party in as much as the award passed by an arbitrator cannot be set aside merely on asking or by the consent of the parties. That means he has gone into this.
No, let's see.
Under backdrop of the submission made by the learned counsel for the respondents, records are examined. Hard learned senior counsel Shri V.K. Jindal, who fairly submit that it would not be necessary to delve into the facts which led to the commencement of the arbitral proceedings and passing of the final impugned award which has put under challenge in the instant applications. Learned Senior Counsel Shri V.K. Jindal submitted that the applicant herein had preferred an application under Section 16 of the Act before the Learned Tribunal, questioning the jurisdiction of the tribunal and maintainability of the claim on account of deviation of mandatory prerequisites of the arbitration clause. The respondent herein filed reply to the application under Section 16 of the Act 1996 filed by the applicant petitioner, and the matter was posted for hearing before the arbitral tribunal. The Learned Tribunal-wide order dated 25/9/2008 did not dispose of the application of the applicant filed under Section 16 of the Act 1996 on the ground that the issue raised cannot be adjudicated without evidence. As such, the issue raised in the application under Section 16 by the petitioner applicant shall be determined while passing final award. Learned Senior Counsel has brought to the notice of this court that the Learned Tribunal has framed issue number 2 and 3, which is the issue raised by the applicant petitioner before the tribunal under Section 16 of the Act. The issue number 2 and 3 are reproduced here. The Learned Tribunal, while passing the impugned award dated 18/1/2020, did not decide the issue number 2 and 3 and disposed of the claim of the respondent. While impugned award, Learned Senior Counsel impressed upon this court that the impugned award does not only suffer from the vote of finding on issue number 2 and 3 by the Learned Tribunal, the application filed under Section 16 of the Act remains undecided. This court finds that the submission made by the Learned Senior Counsel had substance having serious bearing on the impugned award, inasmuch as the issue number 2 and 3 is not simpliciter an issue which has cropped up based on the claim and reply filed by the party, but the genesis of the issues was under application under Section 16 of the Act 1996 filed by the applicant. Any application under Section 16 of the Act ordinary is disposed of before the tribunal proceed further. If the tribunal rejects the application under Section 16 of the Act, the remedy for the agreed party is to challenge the said order along with the award under Section 34. In the instant case, there was no order passed by the tribunal under Section 16 of the Act 1996 filed by the applicant. However, it is not a case that the applicant was left unattended. It was clubbed together at the final hearing, which is evident from issue number 2 and 3. The challenge to the award by the applicant on one of the grounds discussed above, which is placed in ground G of the application, in order to comprehend the ground of the ground G, is reproduced. I am escaping this. On perusal of the reply filed by the respondent, this court finds that there is no substantive rebuttal of ground G referred above. Further, on close reading of the impugned, Your Lordship, this is important. Further, on close reading of the impugned award, this court finds that the tribunal has not returned any finding on issue number 2 and 3. This court, without reference to the decision to fortify its conclusion, finds that, without referring to any decision to fortify, finds that impugned award suffers from, these are the findings, Your Lordship, finds that impugned award suffers from violation of principle of natural justice. The applicant has been deprived of the opportunity of being heard. As such, he was not given fair opportunity to present his case. The impugned award dated so-and-so was passed in breach of Section 18 of the Act. As such, it suffers from the infirmity under subsection so-and-so, so-and-so of Section 34 of the Act and liable to be quashed. This court at the recital had mentioned that the respondent has not registered or defended the legality of the impugned award on the above mentioned ground. Rarely the court encounters a very fair concession made to the admitted position of law. All that this court can do is record the appreciation of the part of learned counsel for the respondent for putting across his duty to uphold the law first, then his professional duty towards the clients. The proceeding before the commercial court will have a real meaning. It will serve its purpose and object only when spirited lawyer undertakes to assist the court in right perceptions. This is a case of its kind, otherwise this case, like any other case, would have dragged on, consuming the valuable time of the court and block other cases. The learned counsel Sri George Thomas present before the court with the official of the respondent Sri Thomas E. Abraham. It is pertinent to note that the impugned award passed by the arbitral tribunal consisted of Justice Satpal, retired, as a presiding officer, arbitrator, Sri I.S. Hacharigan, nominated so-and-so, so-and-so. The learned arbitrator nominated by the respondent, Sri J.K. Srivastava, has given a dissenting award. This court finds that the impugned award dated 18/1/2020 is not sustainable for the reason discussed above. Accordingly, it is set aside. The learned counsel for the respondent prays before this court that respondents may be given liberty to take appropriate action in accordance with law and has placed some authority before this court to substantiate his argument. This court finds that the respondent is entitled to equitable relief for the assistance rendered to this court. The power of the respondent does not run contrary to the contract, nor there is statutory bar. The respondent is at liberty to take appropriate action in accordance with law. Needless to say, the benefit of Section 43 of the Arbitration and Conciliation Act 1996 will be available to the respondent in the event of the respondent seek remedy under law. What he gets only benefit of Section 43(4). Court has applied. And even Your Lordship, that order on Section 16 petition, it's not that...
The next year?
Yes. It's not that the tribunal has not heard him. Your Lordship. Page 40.
1-4.
40.
Is the order on Section 16?
16 application. By this order, we are disposing of the application dated 16/5/2005 filed on behalf of the respondent under Section 16 of the
Where are you
application.
reading?
Page 40 of my affidavit, Lordship, sorry.
Oh. Yes.
By this order, we are disposing of the application dated 16/5/2005, filed on behalf of the respondent under Section 16 of the Arbitration and Conciliation Act 1996, challenging the jurisdiction of this tribunal. In this application, it has been stated that since the claim number 1 and 2 raised by the claimant are not made the subject matter of arbitration, within the stipulated period of 15 days from the date of commencement of the final decision of the respondent, the same cannot be subjected to arbitration in view of the specific provision contained in the arbitration clause number so and so. It is further stated that in view of the aforesaid facts, this tribunal lacks jurisdiction with regard to other claims also raised by the claimant. It is stated that this tribunal lacks jurisdiction since the prerequisites of clause number 66 1B1. See, Your Lordship, my objection was only with regard to the non-compliance of the prerequisites of the arbitration clause. The 15 days time, Your Lordship, is no longer exist now. It is because the law has said that this period cannot be curtailed. You cannot say that after 15 days you will lose the right. No, but objection at that relevant time was there. Now, Your Lordship...
very long order.
Very long order. I will just point out paragraph 13. Paragraph 13.
Yes.
With regard to the contention raised by the learned counsel for the respondent that the claim number 1 and 2 were barred by limitation under Section 37 of the Limitation Act, the learned counsel for the claimant submitted that this point had not even been raised in the present application, and in the absence of pleading, the respondent cannot be allowed to raise this question in the written submission. The learned counsel for the claimant further submitted that in para 18 of the claim statement, it was only stated the first cause of action was deemed to have arisen on 17/11/1999. Your Lordship, here also one point Your Lordship will also notice that cause of action arose on 17/11/1999. And request for the arbitration is being made in 2024. After how many? After more than 2-3 decades. Now, tracing the records and calling the witnesses who are no longer exist, Your Lordship, will be not possible, Your Lordship. especially in a public sector organization, Your Lordship, because people have retired. None of them is available now. And some might have also died, Your Lordship. Your Lordship will also keep in mind this point. The cause of action arose in 1999. If he says it is the continuation of the proceeding, then this application is also barred by limitation.
No, notice the first arbitration 2003. The arbitration proceedings went on for 17 years.
Yes, Your Lordship.
From 2003 to 2020.
Yes, Your Lordship, it went on up to more, 15 years, if I
17 years, if you notice first arbitration as per my note is 12/3/2003,
Yes, Your Lordship.
and the award was passed on 18th of January 2020.
Your Lordship, what has happened that Section 16 application which was heard, it remained pending for order for 3 years.
This order you're reading now?
This order remained pending with the arbitral tribunal for 3 years.
Why?
Because there was no limitation.
So there was no sitting.
There was no
sitting at all.
The matter was adjourned for pronouncement of the order on 16.
It remained like that for 3 years.
It remained like that for 3 years.
There was no sitting in the intervening period.
No, yes, we are also sitting.
No sitting. I mean, no sitting.
No sitting was called. No sitting was called. Because those days there was no limitation of concluding the arbitration. Now within 1 year, presently within 1 year, the arbitrator has to complete. And further extension only by the court. That too only for a maximum period of 6 months. 6 months. Such a provision was not in existence. Earlier arbitration went on for...
Now there's a cap on the fees also of arbitration, correct?
There is a cap. There is a cap. But the cap is also very high, and despite this cap, arbitrator fix their own fees, and this case is by panel of arbitrator, 3 arbitrators. We had earlier also there were 3 arbitrators. A lot of money have been spent by both the sides. No, again
17 years.
It remained pending. Now again, if you go back.
But if to balance equities, now they have fairly submitted that yes, there were some procedural irregularities in the arbitral tribunal conducting the proceedings. Then naturally they were in the hope that by cutting short the entire business for the commercial court, that the matter will go to second reference. Now there is a situation like this, so they must have lost, because if you are open to conciliation for the disputes, that means they are entitled to something.
There is only, Lordship, one possibility that subject to instruction that I withdraw my Section 16 application.
At this stage?
At this stage. And let us go back again to the commercial court. This is, not a legal submission. I'm just... That he says that finality has not come. But here, if your Lordship go through the judgment of the commercial court has written the judgment that in such a manner that he has examined each and everything and set aside the award. And had he said that parties are free to go for second arbitrations.
Oh, the very fact is given them the benefit of Section 43(4).
That, Your Lordship, that judgment...
That we can read to that.
That, Your Lordship, I have pointed out. Section 43(4) does not confer any right.
Does not confer by implication, but...
Even by implication also, Your Lordship...
The limitation not apply, that means that they expect that the petitioner will go and for a second reference.
No, Your Lordship, otherwise it would have said
Notice for second arbitration.
It would have said it so. The second reference only on what point?
I'll just come back in 5 minutes. 1 second. Seems to take some time, this hearing. Yes.
Lordship, I'll just clarify the point which my Lord were contemplating.
Regarding?
By implication under 43(4), that the commercial court has, by implication, Your Lordship, that they have been given right to go for second reference. And in that connection, I'll just point out once again the AIR 1958 Calcutta.
Yes.
It's there only.
Yes.
Paragraph 19, 19.
One nine.
While on the first proposition, Lordship got it?
Yes.
While on the first proposition of matter justice, I may notice an argument of the appellant against it, which was based on section 37(5) of the Act.
Just tell the person outside to keep the voice down.
Your Lordship, yesterday I have pointed out that section 37(5) is in perimeteria the same as section 43(4).
Yes.
I read once again.
Yes.
While on the first proposition of advocate justice, I may notice an argument of the appellant against it, which was based on section 37(5) of the Act. That section provides inter alia that where the court orders an award to be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the period prescribed by Limitation Act for commencement of the proceedings, including arbitration with respect to the difference referred.
Yes.
It was contended that this section showed that after an award had been set aside, a fresh arbitration proceeding could be commenced by a second reference. The section undoubtedly suggests that there can be a case where after an award has been set aside, a second reference may validly be made, because otherwise there could be no point in prescribing a method for the computation of limitation for the commencement of arbitration proceeding after an award had been set aside. But it is not laid down or implied in the section that in every case where an award is set aside, there may be a second reference. The section is concerned only with limitation. The section is concerned only with limitation, and it is not its function to provide whether a second reference may or may not be made. So far as it deals with cases where an award is set aside, its effect is only to provide that a particular period shall be excluded in computing the period of limitation for fresh arbitration proceeding, where such proceeding can otherwise be validly commenced. So, Your Lordship.
So your argument is that even that 43(4) concession also does not vest them with any right whatsoever.
Any right.
For second reference.
Any right, Your Lordship.
Yes.
And so benefit of section 43 are also not available, and in order to have a second reference, the
benefit of 43(4) not available. Fair enough, yes.
Yes. Then Your Lordship will find that that the second reference is not provided in the contract agreement.
Yes, that is noted.
And the arbitration clause.
Yes.
And one more thing, Your Lordship, I would like to point out that when the award was passed, the day on which the award was passed, my learned friend was aware, as he contends now, that the award has not dealt with the Section 16 application. He was aware. Now, on the day when the award was passed, or maybe on the next date, now, if that be the position, that no order is rendered on my application, he ought to have approached immediately to the arbitral tribunal under Section 33(4). Under Section 33(4).
Those additional claims.
Yes, Your Lordship, this is also an additional claim.
How? It's on point of jurisdiction.
On the point of jurisdiction, Your Lordship, this is also a sort of, because
Okay,
entire
that's the
claims are
argument,
based
right?
upon.
Okay, yes, sir. The petitioner knew.
Yes.
Petitioner was aware that Section 16 matter not decided.
And he ought to have come under Section 33(4).
Yes.
At that time, tribunal was available. Now the tribunal presiding officer has died long before.
He has died now.
He died.
Yes.
And in that way, the matter Section 4 would apply. He waived his right.
Okay.
No, this being the position, Your Lordship, my conclusion is this, that so far existence of arbitration dispute is concerned, it does not exist any longer.
Yes.
Any longer. And this point Your Lordship will have to answer, Your Lordship. This
Yes.
is raised in my pleading. Secondly, as regards arbitrability, I have raised the point of res judicata, which on the face of the, for this, answering this question, Lordship doesn't have to go on the evidence. Lordship will have to only see whether the claims were, whether a particular matter was decided or not, in accordance with that. So, for that, no exercise is required on the face of the award and the pleadings. This point can be answered. Second point, I am telling that second reference is not provided in the, this also, Your Lordship, by having a look to the arbitration clause, this can be answered. And with regard to that, my other contention that award was set aside on merit. So that award itself speaks. And benefit of Section 43(4) are not available to him. Highly likely.
Yes. Yes, Mr. Thomas.
Lordship, as Lordship was pleased to mention about a new Supreme Court judgment, I have to go through that. Therefore, Lordship I will come and argue the matter physically. Lordship may take it Tuesday or Wednesday, if Lordship's roster permits.
Which
I will come.
Which Tuesday?
Next coming Tuesday or Wednesday.
So let's see how, let me check the docket, how packed it is. No, just the judgment came to mind. I've not really read it, but it's a recent.
No, we are deeply obliged. We are deeply obliged. That was.
You have to take another date because on Tuesday and Wednesday, there are a lot of hearing matters.
Okay, any day suitable to Lordship. Any day.
We'll take it on next
29.
29. On 6th of March. Is it convenient for you?
Lordship, 6, I have a difficulty. I have another case. 6.
Yeah, then tell us the date, your date.
Other than 6, any day.
7 also. 7 for how long?
7th?
All right. I am deeply obliged.
You're based where? You're in Delhi?
No, I am based in Delhi. Therefore, if Lordship so pleased, can you make it first item as a...
11th, on 11th. On 11th is the first item. On 11th. 11th of March.
As a first item?
On 11th of March.
11th.
As a first item, Lordship?
Yes, 11th of March, yes. Mr. General has concluded his submissions. Mr. Thomas prays that he may be allowed to reply on 11th of March.
That would be rejoined the argument because.
No, he's not argued.
He argued. No,
I don't remember anything.
He argued.
Just accordingly. Huh?
If the document will still be
once it's part heard, it will come first in the list.
Oh, sure. Yes. Yeah, deeply obliged. Deeply obliged.
Yes.
Second call. Item number 1.
The senior conducting counsel is still on legs.
You've got instructions from him?
Yes, Your Worship.
What are the instructions?
We bring that matter may come after some time. After
No, but then you didn't obtain instructions from him.
Correct instructions.
You said earlier on that they're lying with him, you'll collect them from him, the instructions. He's still not free.
Right now he's occupied in courtroom number 1.
We listed on Monday then.
What did this mean?
Not to inconvenience Mr. Kintar. Yes, as the senior counsel is not available,
Can
it's
we
a matter
avoid
Monday.
26, Your Lordship?
Hmm?
We'll avoid 26, Your Lordship, maybe on 28.
27, no problem. It's just a
28,
small matter. 28.
Item 7.
Hearing. Yes.
Your
Can they avail to pensions?
Your Lordship, as per the District Council Pensions Act, there's no bar. But however, as per the Legislative Assembly, there's a bar.
Oh, show that. Where's the bar?
Your Lordship, it's the Act, Your Lordship.
Then, you then.
So far, I'm concerned.
Opt for which one?
Then, Your Lordship, we will avail the MLA since we are
So you
getting
withdraw this
monthly.
one?
Your Lordship. No, Your Lordship, this one I cannot withdraw because there are 4 petitioners here.
In this idling not the others.
There are 4 petitioners.
Why you clump other petitioners here? Then we can close this one also.
Your Lordship, yes.
The other ones also they process accordingly. That order dated, when's the early order?
There's no.
The early order for the other petition. It was dated when?
Lordship, I'll have to. The last. Before that, it was 13/12.
Oh no, it's this year only.
Just recently.
Before that, it was December.
Okay, you come up with that order tomorrow, we'll dispose it of. Then at least for the other 3 respondents, they can go ahead with this council pension, and petition number 1 will opt out from this council. And bring a provision also for this bar.
Otherwise, I'm ready to pay.
then there'll be defalcation.
No, Bhashala also happened the same thing. When he was CM, he was not receiving the pension of Legislative Assembly. He was not receiving during that time.
Yes?
Lordship, the last order, it was 6/2.
6/2.
2024.
What does it say?
Lordship will place it tomorrow.
You place it tomorrow with the order and with the that bar is.
Highly obliged.
This matter tomorrow.
Good day, Lordship.
To enable the counsel of the petitioner to place on record or to place the instructions as received.
Highly obliged.
Good day, Lordship.
Item 14.
This is part matter. This is regarding the poultry attendant.
Yes, poultry attendant.
That case,
who
the
became a
promotion was
driver.
given. She joined because the government.
Well, just come to the facts. Yes. Yes, start.
The fact of the case is that the petitioner was appointed in the year 1981, November 1991, by the Annexure 1, page 12. He said, petitioner is Elias Marvin. He was attended as a poultry attendant. Then 81.
You agree what should impugned order?
The impugned order. The impugned order is page 21.
Page?
Page 21. 21. Annexure 8. 7.
Read it, read it.
With reference to letter number on the subject cited above, I am to inform you that as per finding of the finance account, on checking the record, it was found that Sri Elias Marvin, retired senior grade driver, was initially appointed as by the District Selection Committee, East Khasi Hill, as a poultry attendant, and later he was allowed to officiate temporarily in the post of driver with effect from 12/7/1980 to his retirement.
Till his retirement.
Till his retirement date, as there was no provision in the service rule to promote an office peon to the post of driver, and moreover, it appears that he was allowed the promotion to the post of senior grade driver. Hence, the service has to be reverted back to the original post of the poultry attendant as per the instruction of finance and accounts officers. Since the officiating appointment to the post of driver is highly irregular, it might attract further complications. That is the they have issued.
So he was appointed as poultry attendant.
Poultry attendant.
Then he became a driver.
Then
senior driver.
Senior
but
driver.
then how does it say that as there is no provision service to promote office peon? Office peon is equivalent to poultry attendant.
Poultry attendant.
Is equivalent.
No, poultry attendant.
No, see, he said office. See, as there is no provision in the service rules to promote an office peon to the post of driver, and moreover, a PS is a promotion post. Hence, the service revert back of poultry attendant. Poultry attendant is equivalent to peon.
Is a grade 4 post. Is a
yes, Mr.
He's not a peon, I think.
Lord. Promotion. It appears, my lord, that he is
the same post. Yes, till now he's not got pension.
No, I didn't get any pensions. I didn't get any pensions. And the government said...
When did he retire?
He retired...
in 2019.
2019. After the retirement, then only they realized...
After he retired, they paid his pension?
They said...
PPO prepared, pension payment order, and...
Pension payment
last pay was prepared.
in the scale of the poultry attendant scale.
The pension was given.
They offered. In their reply also they said, you get the pension.
Then why was he not... he was promoted since 1980 and is detected in 2020.
2020.
After 40 years.
After 14 years. That is the case only.
Yes.
And it is not my mistake. I have not done anything wrong. It is the department who has now can they take the ground that there is a mistake.
Where's the service rule that says does not allow?
He says.
Where? That shows that.
Service rule, the ministerial.
Where is that? Okay. Where is it? Which rule? Rule number?
2017.
Right. Okay. These rules are retrospective.
Well, prior to that, there was a draft rule.
No, draft rules. You're not going to. Are these rules retrospective? They are going to apply 2017 rules to a person who was promoted in 1980.
My lord, this will of course not be retrospective.
Then?
My lord. But however, my lord.
No, where is this not permitted, or there's no channel for promotion from peon to driver if he's fit?
There's nothing.
Where show from the rules? Which rule, Mr. Bhattacharjee?
My lord, here of course there is method of recruitment is there, which is at point number 6 or something. My lord is having the rule, my lord. But then of course there is no.
Where are they getting that from? Come.
My lord, method of recruitment, of course there is no clear indication, my lord. Here at point number D covers the chokidar, cleaner, cook, dark runner, pen.
Very good, but there is 1217 rules. Now at the relevant point of time, let's see his promotion order. Where is it, Mr. Qureshi?
His promotion order is?
Where is that? From cook, from, what is that? He said from poultry attendant to driver.
His promotion order also was 2015. Is a page 18. Page 18, Annexure 5. 15. 2015.
Page?
Page 18, Annexure 5.
See, this is also Annexure 4, page 17.
There is a government notification.
By motor vehicle inspector, he's also been tested.
Tested, yes.
On 6 May 2015 by DTO. Yes. And then this is.
And before that also, Lordship, there was a letter, Annexure, page 15. He said, with reference to the letter from so-and-so, I am sending herewith the name of the drivers of the department as per the proforma enclosed for eligibility test from your end. And I passed this test.
No, that's there. The certificate is there also.
Certificate also there, yes. It is certificate. Certificate is given.
Yes. Now page 14. Okay. That's 85. Where's the initial appointment order?
The initial appointment order is?
Annexure 1.
Annexure 1.
Where does it say poultry?
Poultry attendant.
Where does it say poultry attendant?
Number 1.
No, it doesn't say poultry attendant.
In the list it doesn't say, but...
This is a recommendation, my lord.
Recommendation.
As what?
Now in the recommendation, my lord will kindly
right.
see in the recommendation,
on the top, yes.
it says poultry attendant.
Yes.
My lord will kindly see hatchery attendant is there.
No, that's there. Isn't that seen? Yes. So he was promoted, allowed temporarily to hold a post of driver at 85. And then there was a promotion scheme for drivers, and so 25th of March 2015, he was sent for eligibility test. Then he passed, and that is certificate given by the District Transport Authority that he has thorough knowledge of manual repairing, driving. So he's competent. And then he was given promotion. He sat through the Department Promotion Committee, promoted senior driver. And after all that, and superannuated.
Yes.
And for all that, now in 1st September 2020, you say that yes, give authority. In such cases, he brought authority.
No, authority, Lordship, even the rules also not indicated by them. What are the rules doesn't permits for me to get the benefits? They have not, they simply have quoted the rules, but what are the rules? And what are the rules in existence at that point of time?
Well, at that point of time, definitely executive instructions, draft rules, my lord. Now even there are several Supreme Court judgments, my lord, where it says that even draft rules can be taken into account, my lord. If the department is following, observing, my lord, then that also can be taken into account.
My case started from 1980 to 81. Now I retired.
There are a number of Supreme Court decisions, my lord, on that aspect itself, my lord, whether draft rules can be taken into account or not. Now, my lord, if the department is using the rules and the norms, then of course it can be taken into account.
Yeah, what do you say in your affidavit?
In affidavit, they said due to oversight, the entire affidavit.
My lord, in page 3, para 10, 11 is there, my lord. If I'm allowed to read.
For me, affidavit.
Yes, my lord.
Page
Affidavit
3.
of opposition, page 3, my lord.
Can this excuse be given to deprive a person who's discharged the duties throughout his life from 1985 to 2019?
Well, the problem occurred, my lord, when it came to the fixation, my lord, because that is when it was noted, my lord, that his temporary
He was
post to the
enjoying the
driver
skill of
itself.
pay of senior grade driver throughout till his superannuation, correct?
My lord.
Yes.
So because, my lord, there was another similar case in the department, my lord.
Where is that case?
That is not before the court, that is before the department.
My lord,
But we are not before the court.
So, my lord, there also, my lord, he was reverted back, and the pension was settled, my lord, finally.
But was he given notice that the regards promotion, regard to the pay scale is drawing? Was he given notice while in service? After he retired?
My lord, that aspect.
Was he in service?
Yes, he was in service, my lord.
When he was told about this?
Yes, my lord.
That's different.
No, no, my lord. Thereafter he retired, my lord. Similar case, my lord. He retired, thereafter it was noticed, my lord. And then thereafter the department reverted him back. So he had no objection, of course, my lord.
What was the different skill of people, poultry attendant and a senior grade? Let's see. What is the skill of peer poultry attendant?
This is
In
this is as
seven,
far
in
as
page
the-
7, you said that the
This is
scale
as far as the scale of the driver is concerned, my lord.
driver. That
There are
page
two
7 you
grades,
annexed
junior
it,
grade and
correct?
senior grade, my lord. This is the post of the driver, my lord. Promotion scheme
And poultry
for
attendant?
staff car drivers, my lord. The poultry attendant, my lord, there, in fact, I had asked
If you
from
see
the
it's
department, my lord, there is
similar to peon, how much a peon drawing?
my lord, he has not. This is the only appointment order, office order which is enclosed is 12 July 1985, my lord. Where it
No,
is,
I mean now, on a time and how much, now the present scale of pay of the poultry attendants, how much?
that I'll have to seek instruction, my lord.
Get by tomorrow. As we'll pass orders, won't set a precedent, but you can't do this.
But,
So whoever officer is responsible, then
can it come up on Tuesday only?
Tuesday, last chance.
In the
yes.
meantime, I will also try to get a short table, my lord, as to
What table?
My lord, to my understanding, poultry attendant, there is no scope for promotion also, my lord. It ends there. That is
Where
the
is
only
poultry
post.
attendant? This is nowhere in the rules also.
There must be some rules.
My lord.
Where are the rules? Veterinary has their own
My
rules.
lord, I have written to the department. They've
Then
got
veterinary
the
must
rule.
have its own rule.
They
Whether
have-
it comes to
the-
district ministerial
The
establishment
rule
also
that they
is
have
doubtful.
sent me is this rule, my lord.
See, it's doubtful whether he comes to district ministerial establishment rules also.
My lord.
He's under a separate department totally, veterinary. They might have their own rules.
My lord.
Are you aware? No.
No, I spoke to them also, my lord. So
They
they
don't know
ultimately
anything.
they send me this rule. So I'll again, my lord, if it is taken up on Tuesday.
Otherwise, we'll grant him relief.
My lord.
15.
Obliged, my lord.
Just on Tuesday for the hearing. Yes. Ready today?
My lord, on the last occasion, I filed the written submission.
What is
on
submission?
relevant aspect
No one
of-
appeared on last occasion.
Yeah, because I informed him that I'm unwell.
But he was pressing for the
Yes,
hearing.
No, that was before the last day. No?
That's before last date. So that's succession only. First appeal.
First appeal.
Where's your note? It's not here.
Okay, then I'll file for it.
No.
I'll file now.
Only the only thing is here is only on the relevant evidence.
So that's the, as per the direction of this court, I had filed that.
Because the this appellant, I mean you're the respondent.
Appellant, Your Lordship.
He has denied. I mean the respondent denied the marriage, correct?
Yes, Lordship. So we can.
As per, I don't know. I hope it's correct. You're digesting this evidence.
So I'll file the.
Where is it? Why isn't submissions? We didn't ask for any submissions as yet.
As per the order of 20.
Order asked for
26/9/2023, Malad.
Just provide a
Note on relevant evidence.
Note on evidence, not written submissions. Because on
26/9/2023.
Yes. But this is a matter. In the meanwhile, let the counsel provide a note on the relevant evidence tendered by witnesses of trial court. We are sitting in the first appeal. You understand? So first appeal jurisdiction is that we can reappreciate the evidence is been tendered before the lower
I
court.
prepared, but I don't remember whether I filed it or not.
It's not been filed.
Yeah, then I will file it by today.
Give him copy.
Yes.
Then we'll hear it thoroughly.
My lord.
Lordship, just.
When?
Your Lordship, the appellant here is an aged woman, and now she's.
So we'll hear it next week. We'll hear it. This is thing.
It's a fixed matter, Your Lordship. Urgency is there.
This is not we asked for just to. What the court asked was that you condense the evidence, relevant part of the evidence, which tendered by you for the in the trial court. You're for the.
I'm the petitioner.
You're the objector.
He's the petitioner. I'm the
You're
objector.
the petitioner, the objector. Right. You're saying that that you're claiming
I'm
you're
the
married.
legally wedded wife, the first wife.
Okay. Okay, we'll take it up. We'll take a date from her, yes? We'll have it high on the list. Yes. Just a matter on so-and-so for on the date.
17?
I'll do this.
But we don't take a journal, we'll finish off next day. Sang lawyer, what's happened?
His Lordship, as per the last order, I was supposed to bring on record by way of an affidavit.
Yes, what happened?
Your Lordship, we cannot obtain it because respondent 3 and 4 deceased. So we'll have the successor in question is the son of the deceased respondent.
No, I don't understand. What are you saying? Last time you submitted that to both respond 3 and 4. Who's going to be successor?
The successor is the son, Your Lordship.
Then why? Then where's the affidavit for substituting or substituting application?
There's no one to sign the affidavit. Your
Why?
Lordship. The son is a necessary party in this Lordship, but he has not been made a party. So I've served the petitioners a copy of the name and address of the successor in question.
Who's successor in interest? You give it to them.
I've already served it, Your Lordship.
Lordship, the only issue, Lordship, remaining is that we cannot ascertain the date of death, Lordship.
They will provide it to you.
Yes, Lordship.
You give the dates.
Yes, Lordship.
Mr. Lasang Luya, legal counsel for the respondents
3 and 4.
3 and 4 were since deceased. Undertakes to supply the dates of expiry of the said respondents and also the legal heir to be substituted in their place. Just after, then you file, applicant will be filed thereafter by the petitioner. Just after 2 weeks, yes.
Obliged, Lordship.
25?
Yes.
My lord, that way this matter can be taken up after a week, my lord.
This matter is regarding that
That the electricity due, Your Lordship, which was supposed to be paid by the previous owner, not the...
Attorney General is here.
My lord, he has been called for a meeting, my lord.
Doesn't matter. After a week, you have no objection.
Yes, they have expressed their
He was here, my
inability.
lord, before code number 1. After that, my lord, he has been called for a meeting.
On the request of Ms. Arkolni, this matters post-matter after 1 week. Yes, interim orders there.
That will continue until further order, Your
Yes, my
Lordship.
lord, there is an interim order.
Yes.